Hi, my name is Bill Espinosa. I'm an attorney, and I represent a couple of organizations that have an interest in the subject matter, and I have, like someone before me, both a comment and a question. My comment is that Joe, in your discussion of the Treasury was benign, but another agency wasn't in one case. One of my clients is running into the opposite problem. The Treasury is trying to determine what books can be purchased in Iran for civil society. Even after the National Endowment for Democracy has cleared them. So it works both ways. But I do have a question for the lawyers on the panel, and that is, and I think some of this just may be a chilling effect, but what is your basis for believing that simply facilitating a dialogue between two opposing parties, as opposed to providing training, which was the case in the HLP case, is now prescribed?
Thanks very much. So let me give that question both to Emily and to Nathan. Can you speak a bit more to this issue of, so humanitarian aid, as Joel said, I mean, there are some real significant, at least theoretically, issues in terms of facilitating the provision of actual goods and behavior abroad where these groups are active. But what is the concern regarding facilitation of dialogue, peace building and conflict resolution activities that would involve diplomatic affairs? Where does that come into interaction with this decision?
Yeah, with respect to the facilitation, you know, I think this goes back to the breadth of the definition, and would that be expert assistance? We don't know. I think part of the problem is the amount of discretion that it gives the government to determine what they think it means and when to apply the statute, which, you know, as the ambassador mentioned, leads to chilling of activities, you know, even if they don't prosecute. They're all sorts. One thing to keep in mind is that at the beginning of the Humanitarian Law Project case, they asked for the government to pledge that they would not bring prosecution for the activities that they propose, and they could have headed off the entire case by granting there would have been no standing for the groups to then challenge the statute, and the government declined to do that. So that's not particularly encouraging with respect to what they consider to be problematic activity. Other things that that we worry about are things like, you know, if the New York Times were to publish an op-ed by the leader of Hamas, would that be providing material support? If an anthropologist went to study how children are taught to deal with problems in areas where there's violence is the answer to many questions. Will that sort of research be considered support? There's no way to do some of that work without coordinating with the groups that are on this list. And I think there have been examples where the material support statute has been applied much more broadly than you would have expected. So in the immigration context, if you are found to have provided material support to terrorism, then you're barred from being granted asylum in the US. And there are people who have been coerced into, you know, working essentially as slaves for leaders of violent groups, who then come to the US, and based on the fact that they provided a service at gunpoint for one of these organizations, their asylum claim was barred. So, I mean, I agree that it's unlikely that the government's going to prosecute the New York Times or save the children, but A, they could, and that's troublesome, and B, I think there are a lot of sort of more under-the-radar groups that are doing similarly valuable work that are really vulnerable.
Thanks. Nathan, can I ask you to comment on this as well?
Yeah. This distinction between, in my case, training and negotiating or liaising between two conflicting parties, it's a fine one. I mean, maybe depending on how the court or any of this to be prosecuted chooses to define it, maybe it's moot. I mean, we recognize there's a risk there. But in our minds, of course, we would like to show that we're complying. And so this to us is something that could more obviously be considered providing expert assistance. If you're a conflict resolution expert and you train someone in conflict resolution and they're listed as an FTO, then apparently that's material support. So it's what we think we can do. It's where we think we can cut back in an effort to try to be compliant. I would assume that part of this is tied to the court's point about legitimacy, legitimating. I mean, that there was this equation between contact and legitimacy. Again, particularly if you make a distinction between large groups that have a major political following versus very small groups, I think that argument is, by and large, doesn't hold water. I mean, again, the example that I'm most familiar with, Hamas is legitimate because they won an election, not because I have meetings with them. I mean, it's kind of farcical, really. Moreover, particularly in the Middle Eastern context, there are lots of groups on this list. Not only would public contact with the United States not legitimate them, it would burn them politically. The last thing that half these groups want is to be seen as talking to us. So I think much of it is lacking.
Thanks very much. Let me go to